Sorry. And I heard Your Honor in the earlier argument saying that there's no points off for being brief.
No, I won't tell you there are points in favor of it, but you don't lose because you didn't use your time.
Thank you, Your Honor, if it please the court. Your Honor, this is a petition for a writ of certiorari, and it's the position of the petitioner that the trial court denied the procedural due process rights of the petitioner in the ruling on the transcript that's attached on petitioner's motion to strike the answer and affirmative defenses, and that the court's ruling departed from the essential requirements of law, causing a miscarriage of justice. We filed a lawsuit.
Well, let me ask you this, Mr. Stratton. This being a cert proceeding, what do you say to the proposition that you have an adequate remedy by appeal from an eventual final judgment?
Well, that might be 3 or 4 years down the line, and I believe that I'd like to get to the heart of the issue as quickly as I can to resolve the issue. I believe that there is a grounds for this, Your Honor, because the necessary steps to set aside a default are: first, you have to file a petition, a motion to set aside a default, and which you'll see in Exhibit E to my on the Appendix 2 to the amended petition for writ of certiorari. The second thing that was attached is a motion to strike defendant's answer and affirmative defenses. Exhibit E to that is correspondence that I had with opposing counsel regarding the need for him to file a motion to set aside a default. This was back in November, and Mr. Ross took the exact position that he took in front of the trial court judge, which is that, well, he filed his answer and affirmative defenses at an appropriate time. And the trial court judge ruled that that is not the case, that more than 20 days had elapsed after the filing and the service of the complaint, and no responsive pleading or answer was filed, and that the clerk was proper in entering the default. And I alerted Mr. Ross to that fact and suggested that he should file a motion to set aside the default. And Mr. Ross's response was that if I don't withdraw the default, agree to the withdrawal of the default, that he would be filing a motion to set it aside and ask for sanctions under 57-105. That was November 2nd of 2021. Mr. Ross took no action, so I was forced to file the motion to strike his pleadings and move forward because the case wasn't moving. Nothing was happening. There are 3 things that have to happen for the court to grant a motion to set aside a default. You have to file a petition, and you have to show reasonable cause for the delay. You have to show a meritorious defense, and you have to act diligently. And the reasonable cause has to be also supplemented by an affidavit. Mr. Ross did none of those, and the court suggested that he file an ore tennis motion at the hearing on our motion to strike the pleadings, and the court immediately granted it without any of those 3 things happening. So the court didn't have the ability at that time or the right to allow my motion to be stricken and allow the answer to be filed, because the 3 elements of setting aside a default were not met. That's the miscarriage of justice that denies the essential requirements of law, because he didn't show that he had any excusable neglect. In fact, his argument in front of the court at that time on that motion was that he properly filed it in a timely fashion, and that's because his reading of the rule is that the 20 days doesn't include Saturdays, Sundays, or any intervening legal holiday. The court ruled that that's not the case, and that the answer.
Mr. Stratton?
Yes, Your Honor.
If we grant your cert, and send it back to the trial court, would Mr. Ross have an opportunity then to file his motion to set aside the default and answer all the things you're saying?
No, I don't believe so, because if you're ordering it back and the court grants the motion to strike the answer in affirmative defenses, I don't know that he would be given a second chance to file an answer in affirmative defenses.
Well, why wouldn't he? I mean, it would seem like, I think, as I understand it, Mr. Ross thought he timely filed his answer of his affirmative defenses. And I guess he really didn't realize he didn't until he got to court that day. And the trial judge said, no, you didn't get it timely. But why wouldn't he have a chance to do it right instead of, the overtennis motion like you're saying?
Well, because, Your Honor, I believe that the case law is very clear that the excusable neglect in failing to respond does not include ignorance of the law or failure to understand the consequences, that those are not viable excuses. And I cite to the court the case of Somero versus Henry General Hospital, 67 Southern Second.
We find out, I guess.
Yes, Your Honor, that's very true. But I mean, that's our position, that Mr. Ross was given. I spoke to him in early November about this, and by January, when he hadn't acted, I had to do something to move the case along. And I believe that the trial court properly ruled that he needed to file a motion to set aside the default. And he hadn't filed a motion at the time when the court ruled on that motion immediately on an ore tennis basis without Mr. Ross complying with the prior rulings of this court and every other appellate court and the Supreme Court, saying that in order to set aside a default, three things had to happen. The defendant had to show excusable neglect. He had to demonstrate a meritorious defense, and whether subsequent to learning of the default that the defendant demonstrated due diligence in seeking relief. Well, Mr. Ross didn't seek to do anything. There's no due diligence here. And I believe that the case law is clear that there's no excusable neglect because of his mistaken reading of the law. And I believe that the trial court thus should be ordered to grant the motion to strike the pleadings. Mr. Ross is sitting and saying, and said that he was going to act and he didn't act. And I don't believe that he should be rewarded for failing to comply with the requirements of 1.540B in trying to set aside a default by not doing so. And I believe that that was a departure from the essential requirements of the law, and it caused a miscarriage of justice. Thank you very much.
Thank you, Mr. Stratton. Mr. Ross, you're up.
May it please the court. Tim Ross representing the respondent. How silly of me to try to follow the discovery handbook rules and try to work things out with my opposing counsel before, actually having to take up the court's time. So there were back and forth, but frankly, I filed an answer and affirmative defenses. The clerk accepted my filing. There was no, I know that all courts, especially this court, understands that things should be adjudicated on the merits. This is a little unusual because of the fact that the court, I guess it's Mr. Stratton's argument that the court improperly accepted my answer and affirmative defenses. I think I should be allowed to rely on the fact that the court accepted my pleadings. And very simply, no final judgment of default was ever entered. There was apparently a clerk's default Well, my understanding of the law is you got to take that one step further. And that is to get a default from the court. I filed a pleading. The clerk cannot enter a final judgment against me without a hearing. I filed pleadings. There was no harm and no foul in this case. Very simply, and I don't want to take up any more of the court's time than I need to. I don't see the harm in the fact that I won't do this again. I'm going to throw out the discovery handbook, and I'm just going to, cause all kinds of extra court time. So I think everything was done on my end that I could do. I do not control the clerk's office. I do not control when the clerk dockets a pleading which I filed. Frankly, this is an unusual case to me, that's for sure. Listen, whatever the appellate court rules, but trying to be a nice guy is a bad idea in our business. So thank you, guys.
Thank you, Mr. Ross. Mr. Stratton for rebuttal.
Yes, Your Honor. In order to have a default set aside, there has to be a motion filed. You have to show excusable neglect. You have to file an affidavit showing the excusable neglect, and you have to do so diligently. The clerk entered a default. The fact that the clerk did not return Mr. Ross's pleadings should not give Mr. Ross any benefit. He was informed by my office in the beginning of November that he had to take action to set aside the default. The default wasn't improperly entered. And the trial court, in allowing him to foray tennis, move to set aside the default and have the court granted without going through the requirements that are set forth in Florida Rule of Civil Procedure 1.540B and the case law, is a miscarriage of justice. That's our position. Mr. Ross shouldn't benefit from his failure to comply with the rules of civil procedure. And the court has already determined by that time that Mr. Ross needed to set aside the default. Thank you, Your Honors.
Okay, thank you both. You want to leave our virtual space here. You need to click the leave button, which is on your Zoom screen. It's in red. You will fly off into the ether somewhere, and we will proceed. You'll be here.
Thank you.